Thank you, Mr. Chairperson. Thank you, members of the committee, and ladies and gentlemen. I'm really grateful for the invitation and the opportunity to be present here and to discuss with you very important issues for Ukraine. Democratic Europe supports Ukraine. We feel this political and diplomatic, financial, and humanitarian support, and we thank every member state of the Council of Europe for that. And I believe we all agree that it's not just the war for Ukraine, but a global war, and that is putting international peace and security at risk. And we firmly believe that international community shall act without leniency to hold Russian terrorist regime accountable for atrocities and destruction. Regrettably, every day the aggressor causes new destruction on the territory of Ukraine. The material destruction is unimaginable, and it continues on daily basis. Shattered cities, damaged vital infrastructure, environment and ecosystem, cripped economy amidst massive human losses. Therefore, there is a need to create a new and innovative compensation mechanism to collect, assess, and ultimately provide compensation for hundreds of claims against the Russian Federation and direct losses stemming from this aggression in the territory of Ukraine. On November 14th, the United Nations General Assembly, 94 states voted in favor of the resolution, which established the need to hold the Russian Federation accountable for violations of international law.
All right, everybody, all right?
Okay, should I be slower or? There was established the need to hold the Russian Federation accountable for violations of international law. There was established the need to create the international compensation mechanism for reparation of damages, loss and injury caused by caused to Ukraine by Russian Federation. And there was recommendation to the member states to create an international register of damage. Before that, in September and October and in November, political support for the creation of the compensation mechanism was expressed by the Council of Europe and the Parliamentary Assembly of the Council of Europe. We appreciate a lot these decisions. Once these resolutions have been passed, Ukraine started to implement this strongly voiced political willingness into practical steps. So I would like to briefly remind that the main concept of the international compensation mechanism is the construction of coherent system for securing real compensation for damages caused by the aggression under multilateral international agreement. Fundamental provision of this international agreement is to establish and consolidate the responsibility of Russia for aggression and hostilities against Ukraine and steady obligation of Russia to compensate material damages. The compensation mechanism shall provide for the establishment of the Compensation Commission, especially dedicated to consider compensation claims, the Compensation Fund, from which the compensation shall be paid, and an effective procedure of enforcement of the Commission's decisions. From the very beginning, we decided to take an incremental approach, and for further implementation of such a comprehensive mechanism, an effective instrument is needed, which will become a guarantee of the effective operation of the mechanism and the basis on which the design of the Compensation Commission itself will be built. And that is, as stated in both UNGA resolution and Committee of Ministers resolution, the establishment of the International Register for Damage for Ukraine. That would serve to record in documentary form of evidence and claims information on losses, injuries and damages to all natural and legal persons concerned, as well as the state of Ukraine caused by the Russian international wrongful acts in Ukraine, as well as to promote and coordinate evidence gathering process. Such a register of damage will be an integral part of the compensation mechanism, or in the other words, it will set up as a sui generis system that would set the infrastructure for a future compensation mechanism sought by Ukraine. At this stage, we propose that the register of damage is for Ukraine be partially modeled following the example of UNGA register of damage caused by the construction of the wall in the occupied Palestinian territory established under UNGA resolution of December 2006. So But we think that this register should not be under the auspices of the United Nations, and it was not specifically mentioned in the UNGA resolution. That's why Ukraine is taking steps in order to set up the international organization. We have already conducted several forms of negotiations with the parties who would become interested in hosting this this register of damage. The register will be independent. It will have the mandate to aggregate information on claims and evidence supporting them, organize claims, assigning categories, grouping them into mass class claims where appropriate, assess claims from the point of view of prima facie and admissibility criteria, territoriality, temporality, causality, and ultimately record the admissible claims in the register. The register of damages would use rules of procedure developed by its bodies within the framework of principles set out in the founding treaty or charter. Register of damage for Ukraine is not intended to be set up as a claims commission with an adjudicating function at this stage. However, it is envisaged that the same international organization could be at later stage expanded to carry the adjudicatory function. So legal basis for the register. The register will be an independent organization, as I mentioned, founded by a multilateral international treaty or charter. Ukraine expects to make an initial proposal to join as founders to the host state, G7 members, European Union and its members. In principle, the organization should be open to all like-minded states and regional organizations in line with the spirit of the resolution of UNGA. At this stage, we are considering two approaches to setting up the register. One is to set a technical international organization by just two states, for example, Ukraine and the host state, in order for it to attain legal personality, so that it could go through all pre-set up stage as quickly as possible, with other states joining in the process. The other approach is to focus on drafting a proper charter of the organization that would serve as its foundational instrument that would be signed by the participating states, with a pre-set up commencing later or ongoing in parallel and technically outside the organization. Selection of one of these choices will depend on practice and preferences of the host country, as well as the outcome of the discussion at G7 level, which is anticipated next week. Register of damage will be composed of a secretariat with administrative functions and a commission with a supervisory and adjudicating function. The commission will have three main tasks: overview of the collection of the claims and evidence thereof, reviewing and assessing claims received, overseeing and directing the work of the secretariat. The Commission will draft its own rules of procedure and operation based on the guidelines of the establishing document and existing best practice. It will also prepare the claim form or its digital equivalent to collect claims and evidences, as well as its established procedures for the collection, processing, and registration of claims, including the claims eligibility criteria that will be directed by establishing instrument. The Secretariat will assist to work on for the Commission. Specifically, it will assist with the managerial aspects of the register and including hiring staff, be in charge of daily operations of the register, including its financial aspects, assist with the collection, processing, and preservation of claims and evidences, and managing the digital platform of the register. The Secretariat is headed by the Secretary General, who will supervise the other members of the Secretariat. Personnel will include junior and senior legal staff, data analysts, computer data experts, legal and administrative experts. The Secretary General will be appointed by the Commission or by the establishing parties. We opine the location of the register in one of the European cities is an advantage for reasons of convenience, cost, and experience of hosting international organizations, as well as the readiness to provide financing, immunities, and other necessary support. Register of Damage for Ukraine should enjoy immunity and protection with respect to its premises, equipment, servers, funds, bank accounts. The register will be secured sufficient office space in its location so as to be able to host a permanent secretariat, registry of claim and evidence, and the operation of the Commission. At present, the urgent task is to collect the claims. This will require developing, distributing, and collecting claims forms. This will likely require also extensive travelings and dedicated personnel. In a second phase, the personnel required will be lawyers who can provide an additional review of the claims, and statisticians, data analysts, who can process the claims and data and create databases of claims. Given the unprecedented scale of the damage, we discussed the use of digital platform for the registry to submit claims and evidences. And in this respect, work is ongoing with the digital platform, on designing the digital platform based on the DIA system, which is developed and used by the Ukrainian government. The digital platform will seek to automate the process to the extent possible, including submission of data, verification of identities of claimants, evidence such as title to property, geographic and temporal data. Taking into account that there will be extremely large amount of claims and submitted informations and documents in Ukrainian, the intention is to use various emerging technologies such as character and language recognition and processing, machine learning to automate, categorize claims and group them into mass group claims where possible and appropriate. Interaction of this register with the Ukrainian state registers on legal entities, on property rights, real estate, land register, and others. As envisaged by the UNGA resolution, the work will definitely be coordinated with the collection of evidences conducted by the domestic law enforcement bodies and the International Criminal Court in the process of investigation of war crimes. And the Secretariat will oversee the use of technology and coordinate the evidence gathering process with other holders of the collected evidences. Special focus will be dedicated to the issue of security of the digital system of register against physical and cyber attacks. It will be of utmost importance having known the possible sabotage Russians might undertake. Estimate budget requirements. Several factors affect the operating cost of the registry of damage, including its location, personnel cost, and the number and complexity of claims. Drivers of cost will also include speed and order of priority of claims resolution and the length of the Commission's mandate. Ukraine's proposal is that the registry of damage for Ukraine be financed through voluntary contributions of participating states and international financial institutions. In this sense, was envisaged an aggregated budget from which capital and operating expenses of register would be covered. It can also make sense, however, that some forms of contributions are made in kind. For example, a host state could provide premises for the organization and its physical security. Core functions of the registry of damage and steps to be taken once established. Once established, the Commission will be tasked with collecting and reviewing claims. It is envisaged that claims will be submitted by natural persons, juridical persons, state-related entities, and the state of Ukraine. Claims can roughly be grouped in the following categories: claims by displaced persons, claims related to war crimes, including victims of conflict-related sexual violence, claims for personal injury or death of an immediate family member, individual claims for damage or loss of property under a certain threshold, for example, $150,000, individual claims for damage or loss of property above this threshold, claims of corporations, other private legal entities, and public sector enterprises, and claims filed by the government of Ukraine and potentially other governments, including for damage caused to infrastructure and the environment. I also need to mention that our idea is that the enforceable monetary judgments of ICJ and ECHR investment tribunals against Russia's Federation on the losses caused by this aggression, as well as illegal annexation of Crimea, should also be monetized through this compensation mechanism. That is why we believe that Council of Europe should be very interested in facilitating of the establishment of this mechanism through encouraging its member states to join it. So to sum up, we intentionally do not address the issue of setting up a compensation fund and the sources of its financing, as we want to build out the needed infrastructure of claims collection and adjudication. In parallel, we are working with the states on the viable legal framework for seizing of frozen Russian assets and funds, and it will take time to introduce needed amendments to the domestic legislation of the participating parties. As an alternative to the option of seizing Russian assets, there might be financial instruments proposed by the parties to the agreement and international financial institutions, also similar to Iraq-Kuwait scheme of financing the compensation fund through revenues from oil and gas export deals of Russian Federation. It requires the consent of Russian Federation, but might be an option for paying reparations against confiscation of reserves once they are ready to talk about peace, or establishment of the effective simplified procedure of enforcement of the Russian assets, with the possibility to lift jurisdictional immunity from enforcement of the Compensation Commission's decisions. But what we ask the states now is to maintain measures at keeping the frozen blocked Russian assets until the legal solution is found with their seizure to the compensation fund. So that is what we call an incremental approach. That is how the government of Ukraine decided to move in order to implement the resolution of the General Assembly, as well as the decisions of Committee of Ministries. And that is how we see the process of establishment of the compensation mechanism per se. Thank you.
Well, thank you very much for that, and for all the work that you've done behind the scenes to deliver this project.